talk too loud anyway. So I'm going to be giving you comments on commenting on EIRs and things. First off, a little bit about my background. I've got 5 CEQA cases right now that I'm the attorney on, and some of them are pretty big ones, like opposing the first 2 phases of Newhall Ranch, which is the largest housing development ever approved in the state of California. So CEQA, a lot of those cases have land use claims under Subdivision Map Act and the Planning and Zoning Law. I've also got a couple of Public Records Act cases and a Brown Act claim. So my practice area is generally CEQA land use, open government, and water law. This is a summary of what I'm going to be talking about today. First, I want to go over the handouts a little bit, just to show you what's there, and so that you see the stuff in the handouts. I want to talk about political versus legal purposes in commenting. CEQA litigation strategy as it pertains to comments you might make on these environmental documents, and then commenting on the different types of documents. So let's look at the comments, the handouts for a minute here. There's the schedule on the front. There are speaker biographies next, which, it's pretty obvious what that is. On the next page are called websites and books. There are some resources that are useful. The first one is the workshop website, where you ideally found EIRs to bring the comment on today during the commenting workshop. That page is where we'll post the PowerPoints probably within a couple days, and the recordings that are being made by
Michael Forbes.
By Michael Forbes in the back. That'll probably take a little longer than that. The Loyola powers that be are also in some sort of unseen Big Brother-ish way recording everything that goes on here too, and that might end up there. But that'll be a resource and a semi-permanent memorialization of this workshop. Online CEQA resources is next. First, there are the statute and guidelines maintained online by the Office of Planning and Research, which is the governor's, it's a department, I think, of the resource agency in the executive branch that deals with CEQA regulations. They put out the CEQA guidelines, which are semi-law. They're an important part of the CEQA. They're essentially CEQA regulations that don't have quite the force of the statute, but almost. There's also a summary of a bunch of case law on that same website. And then third, at the bottom of that section is this thing called the CEQAnet database, which is the state's database of all the environmental documents that have been sent in to them. So MNDs and EIRs and notices of preparation and so on and so forth through the alphabet soup. A lot of those get sent in, but it's not complete in the sense that it has every EIR in California in it, or all the environmental documentation, because local agencies are not required to send in their documents to the CEQAnet database unless a state agency, as opposed to a local agency, unless a state agency has a discretionary permit. If a state agency is a responsible agency under CEQA, then they're required to send their documents into the CEQAnet database. Otherwise, they're not. So you can't use that as a way to find out everything that's going on in Los Angeles that you might want to comment on. It's not there. But there's a lot of stuff that is there, and sometimes agencies send in things even when they're not required to. The next little thing is on CEQA and NEPA books. The community guide to CEQA, I'm fishing out my copy here. It's sort of a loose leaf thing like this big, published by Planning and Conservation League, PCL, is a great and wonderful resource. It's a real quick overview that is legally accurate and fairly complete of CEQA. And this is the first thing you should go to if you're an activist, is, get this book. It costs $45, but they say because it's color, that's what the print cost is. But get this from PCL. You can find it by going to pcl.org online. The other two books listed here are lawyer-type treatises, and you can find those in law libraries. There's the Remy Thomas Moose Manley book from Solano Press. It's not available from them right now because they're doing a new version, supposed to be out by the end of the year. But you can find it in the law library. By the way, if you don't look like a homeless person, you can just walk into the Loyola Law Library here, and it's a good resource to use. They don't check your ID card. So you have to dress yourself up a little bit before you go there, but not too much. So they have the Solano Press book. They also have the CEB practice guide, which the practice under the California Environmental Quality Act, which I think is the best overall CEQA treatise. So anyway, those are highly recommended. A couple more resources on the Public Records Act are listed here. The Calaware books you can get on Amazon. Just type in Calaware at Amazon. There's one on the PRA and there's one on Brown Act. And there's also a website that I maintain called calpublic.org, which has pointers to a bunch of other information. So then there's this little chart, and Tom tells me he did a similar one, so we'll compare it and see if we got the same results, when we get any on our homework or not. But it tells you what the various acronyms are for the CEQA terms and corresponding NEPA terminology, because what he will tell you this afternoon is if you know CEQA, you know 90% of NEPA. And everything transfers over, but it's a different name for stuff over there just to keep everybody confused who's not a real bureaucrat. Then the CEQA process flow that Jeff was making fun of as being so complicated, and it is, but it's here. This is Appendix A in the CEQA guidelines as the chart that Vic points you to. Kind of the other really important thing there is Appendix G. These are online at that leginfo. Well, yeah, they should be in leginfo.ca.gov as well as the series site that's listed here for CEQA. And then last but not least, we have a sponsor profile thing. The cost of the food and some of the other expenses are paid by these 4 law firms who are sponsoring this workshop, and so you might want to read some information about them. Advocates for the Environment, my own nonprofit public interest law firm, has a little card that you probably got when you signed in, but the other ones are listed here at the end of the handout. So that's the handouts. They'll be available on the website as well. So let's talk about first political versus legal. The reason I asked Jennifer to tell you about the planning matrix here was so that we could talk a little bit more about and refer to this political side. What are you trying to achieve with your political comments? I remember the first time I walked into a citizens group, a local citizens group meeting. It was about 10 years ago, and I was just a hiker before then, and I came to a meeting about Canyon Hills, which was this horrible housing development that they were putting up across from my favorite trail. And I didn't know anything about any of this, and there was a group of 7 community organizers that had Michelle Stone and Fred Dong from the Sierra Club and a bunch of other people and a lawyer there. And it didn't take me long to realize the political and the legal sides are completely separate. That they're totally different things you want to achieve. So on the political side, when you comment on the EIRs or you do whatever you do, you're trying to influence the decision makers. And so if it's typically a board of supervisors or a city council, if it's a local agency approving something that you're trying to influence, and you do that by getting a bunch of their constituents, the people who vote for them, to say, no, this is bad, or yeah, we want this project. But your political purpose is to change the mind of the decision maker. On the other hand, if you're doing the legal side, what you're trying to do is set yourself up for a lawsuit if you want to sue. There are certain things you need to go through in order to have, at the end of the day, a viable lawsuit on this thing. And it doesn't mean you have to sue. And actually, there's a certain amount of convincing the decision makers you're going to do by setting up for a viable lawsuit, because they all know this. You know, they don't want to get sued. The city and the county don't want to get sued. So if they see that you're not setting up, you don't have any decent comments in the record, or for some other reason you can't sue, then they're going to take you less seriously. But by commenting during the EIR or NND process, you're doing one of those two things, either the political or legal side, or both. Just a word about process. You know, lawyers are big on process, partly because what we do is we sort of take onto our shoulders all these disputes, you know, in a concentrated fashion, especially when we're litigators. Other people's disputes we're dealing with in a sort of confrontational way. And rather than have all that kind of negative confrontation energy, we think about, well, what's the next step? And so for a lawsuit, we have like file a complaint, get the answer, get everybody served, do the discovery, you know, blah, blah, motion practice, and then we have a trial or a hearing. And focusing on that takes our mind off the sort of intensity of the real problem. Well, one of the things I noticed in that meeting 10 years ago I walked into is all of these activists who were really experienced activists were focused on the process. They knew this, you know, it's like, oh, it's DEIR time. Okay, we get ready to comment, we get everybody out, we mobilize the commenters, and then we get that in, and then we wait for the FEIR. They're so focused on this process. I mean, they know it so well, but what I want to say to you is that process is important and you have to know it, but you also have to think about why you're doing everything, because it's not just going through the process. You are commenting on this EIR to achieve something. You want to get something in the record that's going to help litigation. You want to get something in there that's going to convince somebody of something. Why are you doing each step? You know, don't just focus on the process and go through it, but at every step when you're doing something, think why am I doing this? Because you always have resources that you could expend on something else. And so you want to make sure you're expending them on the right stuff. So, CEQA litigation strategy, just kind of an overview of why you want to comment. Jennifer already talked about political strategy. You're trying to influence the decision makers, and you're trying to influence the people who influence the decision makers. And the messaging is really important in that. You want to have a unified message that's effective. So that's part of your planning. This carries over, of course, onto the legal side. When you're doing the litigation, you want to use that same message because you're trying to convince people that you're right. And it's not just a technical legal argument. You want people to think, you want judges to think, gee, these people make sense. They have values. They're supporting values that I care about too. That always helps, even when there's a technical legal argument against it. The second thing was, the can't obtain a remedy was a point that Jeff made. You can't stop the project by suing under CEQA because they can adopt this statement of overriding concerns. CEQA cannot by itself stop a project. It just requires that the city or the agency, be it a city or a county, a local agency, or the state agency, consider the environmental consequences. That's what it was forced to do. The idea was before CEQA, people would just adopt these projects, and they have no idea what the environmental consequences would be. And then with CEQA, they're forced to prepare this documentation, and the decision makers, like the Board of Supervisors and the City Council, are required to, well, I'm not sure they actually read this stuff, but somebody does. You know, somebody down in the planning department reads it, and the staff members of the supervisors read it. And so it filters through, and they have to look this in the face and say, yeah, we want to do the project anyway. Even if it's going to like devastate the entire west coast of the United States and destroy all the biology, you know, it's worth having this housing development to do it. They have to make that decision. And they kind of have to do it on the record too. So that's the statement of overriding concerns. It's worth doing it for economic reasons or whatever, even though it has these bad consequences. So that's what you can force them to do, but you can't force them not to do the project just because it's environmentally disastrous. But, on this what you can get part, I've gotten a lot of flack from my fellow environmentalists who say, this is an abuse of CEQA, at least in sort of a legal sense. We sue to delay projects, we sue to get a bargaining chip in the litigation with developers, and the CEQA reformers, I'll talk a little bit about that at the end. There's this big push that's been going on for several years in the state legislature to water down CEQA, to eliminate these abuses, as they call them. They point to this and say, look, you're doing the wrong thing. But generally a person's subjective reason for bringing a lawsuit is not an issue in the lawsuit. I mean, there's this malicious prosecution that you can sue somebody for if they abuse the process enough, but they have to have a claim that's so legally frivolous that it can't really be maintained by a competent lawyer. And we're not ever doing that when we do these CEQA lawsuits. So in my mind, these are legitimate purposes. We sometimes, like Amundsen Ranch, you can delay a project to the point where it is economically infeasible, or you can get one more vote on the city council or something. But you're sort of hoping sometimes you can stop the project that way. It also gives you a bargaining chip with the developers. They don't like having these lawsuits hanging over their project for 2 years. They want to get their entitlements and sell to somebody else and get the hell out of them. So if they've got this lawsuit, then it's like, oh, then the buyer is going to either want to discount the price of the thing, or it's a cloud over the whole thing. So sometimes you can get them to give you something. You file this lawsuit, and you get this bargaining chip, and then you settle with them for an improvement in the project to make the lawsuit go away. Okay, so if you remember, there's a process, early in the process, there's this thing called scoping, where the agency tries to figure out how many issues should be in the EIR or the MND. And so what you're trying to do generally there is to give them more issues to consider. You only want to sort of broaden the scope of the environmental documentation. These things are generally not litigated though, so that's what you're usually trying to achieve there, is get them to consider all the relevant environmental effects. And then they do an initial study, and this comes out with a negative declaration. And it's usually based on that Appendix G that Dick was talking about, which is a little checklist of possible environmental effects. That's not a definitive list of all the environmental effects, but it's one that's sanctioned by OPR, so most people use it. But you can make a case that there are other important environmental effects that aren't on that list that they should be analyzing too. So the legal standard, what you're usually trying to do with an MND or a negative declaration is to force an EIR. And what you do is you make this fair argument based on substantial evidence in the record that the project may have a significant adverse effect on the environment. I'm going to talk about substantial evidence in EIRs in a little bit, and when you get to the EIR, the substantial evidence factor is working against you. For reasons I will tell you. But here, the way the substantial evidence works is, I say this, you say that, we both have evidence in the record, and then somebody looking at both of those things decides. And so, if you're then coming back and reviewing that decision, who wins? If it's a war of experts, as Jeff mentioned, here, we win. If there's evidence that this project will kill the gnatcatcher, and then there's evidence that it won't, and that killing of the gnatcatcher is a significant environmental effect, we put the evidence it'll kill, they put the evidence it won't, we have substantial evidence to support our point of view. Therefore, we have a fair argument based on some evidence in the record is what it really boils down to. And even if there's a war of the evidence, whoever's deciding this thing, like a court, you ask the court to review that decision, they're going to say, we have that evidence, and even if there's a war of evidence, we win and there should be an EIR. So I think Vic was saying that it's relatively easy to force an EIR. You have to get evidence that there will be a significant environmental effect into the record. And that's what you're trying to do when you comment there. You want to put that in. So it has to be evidence, though. It can't be just your opinion. So it should either be some kind of factual, like a study, somebody walked around the property and found the birds or something like that, or it can be an opinion of an expert, or if it's something like traffic, you might be able to use your own personal experiences to say, I live right next door and the traffic's been really bad, and if we have 200 more houses there, it's going to be just out of sight, so it's going to be a significant effect. There are times when your personal observations, it's your personal factual knowledge, you know this stuff from your own observation, that's evidence, and you can put that in. Okay, and then for MNDs, I mean, the way it's supposed to work is they do a negative declaration, a straight negative declaration, if the project just will not have a significant adverse effect on the environment. And they go through that checklist and say, well, it's not going to do this, it's not going to do that. They do an MND if, well, the project will have significant adverse effects, but we can take care of them. We can mitigate them into insignificance. So they have to go through that whole list and say, this one, which would be significant if we didn't do anything about it, is going to be mitigated by doing this mitigation measure. And it's a measure that's been agreed to by the applicant because the agency usually can't force the applicant to do it. So it's something that the applicant is going to do, and it will mitigate the effect so that it's not significant anymore. So you look at those and you say, no, this is not going to work, or it's improperly deferred. It's like the one Jeff came up with, where we're going to take care of this in the future. We'll do a traffic study, and if there are any problems, we'll deal with it. No, you can't do that. You have to specify now measures that will be effective, and you know they're effective. So those are the kind of comments you want on MND. And I think it was Jeff who was saying that the big jurisdictions usually don't make such egregious mistakes, but some of these smaller places will just do MNDs when it's so obvious you should do an EIR. And these suits are pretty easy to win. So you really want to look out for that, and but to get those suits, you need to put the right comments in the record for reasons I'll get to. Now we move on to EIRs. So what's happened up to this point is there's been a scoping something or other, and then they did an initial study, and they decided that the project might have a significant effect on the environment, so they have to prepare an EIR. So they did a notice of preparation, which put everybody on notice that there's going to be an EIR prepared, and then time went by, and they came out with this EIR. So an environmental impact report is supposed to analyze adequately all the significant effects that the project might have on the environment, and is supposed to discuss possible mitigation measures for each of those, and possible alternatives to the project that are feasible. And there's going to be the project they really want to do as an alternative. There's going to be a no project alternative where they just leave everything alone. And there's supposed to be a reasonable range on top of that. So when you're doing political, you know, what you want to say, what you typically say is, this is a sucky project. You guys shouldn't do this thing. So, you know, my little Andy Warhol quote here, when you make comments like that, they're not going to be legally effective. But if you get enough of them, they will be. So if you can get 500 people to mail in comments saying, I hate the project, it's all going to go in the EIR, and they're going to all respond, well, this is not a real environmental issue, but we note your comment for the record. And that's the response you're going to get. But the politicians are going to see all that stuff, and you know, if there are enough people who hate this project, they're going to take notice of it. So that's the, you know, instead of weighing it, instead of reading their publicity, they're going to be seeing that you have 1,000 comment letters in there, and that's kind of what you want. But ideally, you have the message of your campaign in there. On the other hand, completely separate, is your legal stuff. And you're saying there generally not that the project's bad, because that's not going to get you anywhere. They can do the project even if it's bad. What you're saying is your EIR is bad. You have not analyzed the environmental impacts well enough. So let's talk about this thing called exhaustion, which was touched on a little bit before. This is the exhaustion of administrative remedies. This is any time you challenge the decision of an agency, federal agency or state agency, pretty much all the time. What you have to do is go through the process at that agency as high up as you can. And that's called exhaustion. You've like used up all your administrative remedies. In the context of our typical CEQA EIR approvals, it's usually a city or a county, a local agency. So there's a part in CEQA that says if the decision on the project is made by a non-elected board, then the decision has to be appealable to the elected officials, to the legislative body. So that's for a county, the Board of Supervisors; for a city, it's the City Council. And some jurisdictions have appeal ordinances, some do not. But you can appeal anyway. You just appeal. So if your decision is made by the Planning Commission and you don't like it, you have to appeal to the Board of Supervisors or the City Council. There may be intermediates along the way. In the City of Los Angeles, it'll go to the Plum Commission before it ends up at the Plum Committee of the City Council before it ends up at the City Council. But you have to do that. So there's a requirement that the quote exact issue, you know, when you're a lawyer and you see something like exact issue, it's like, oh my God. But you can't really always figure that out. But the point for you making your comments is you want to comment fairly specifically about exactly what you're saying is wrong with the EIR. And the closer you can get it, the less your lawyer is going to have to fight it out later that you didn't do the exact issue. So, the exact issue of what's wrong with the EIR. And then there was a question about sort of standing. This, by the way, is a generally accepted, judicially created rule. This is exhaustion of administrative remedies, but both in the case of CEQA and for the land use statutes, the Planning and Zoning Law and the Subdivision Map Act, it's codified, it's in the statute. And what the CEQA statute says is that the issue that you're litigating must have been raised by somebody during the commenting process up until the final hearing is concluded, which means until the end of the City Council meeting, basically. You don't have to raise it during the official commenting period. And the person who is going to sue, which I call here the petitioner, it's sort of a fancy legal term for the plaintiff, really, in these kind of cases. That person must have objected to the project in the final stage at the City Council meeting or Board of Supervisors. And I know people who've lost on this. You know, somebody, I know an activist who made all his comments on behalf of his organization, and then he wanted to sue in pro per, like you can sue without a lawyer. Useful for all years, that's one thing to do maybe. But he didn't make the comments on behalf of himself. He said, I make them on behalf of XYZ nonprofit. And so he lost his lawsuit because he didn't raise the issue himself. He said it on behalf of somebody else.
I want to make sure that I understand this clearly. If the decision is made by a non-elected entity, you can appeal to the elected entity, but you must do so in the final administrative stage, and you must use the name of the person. You must do so as a petitioner. You will be.
Yes, that's it.
I mean, if you want to sue individually, but if you're only suing an organization.
Well, if it's an organization who wants to sue, then that organization needs to make the comment. If you're an individual who wants to sue, that individual needs, I mean, all I have to do is say I object to the project. You send in a letter, we just stand up at the hearing, and that's it. And so it's two parts of the exhaustion are the issue must have been raised and the person must have objected to the project.
Sorry, just to be clear, but you don't have to have raised that issue yourself.
Right, right. You don't have to have raised all the issues, but somebody has to have raised them.
Is it important that you say in your letter, and I wish to include all comments made by others?
No, it's not important that you say that you include all comments made by others. We have to move on. I'm probably running slow anyway. So, actually, how much time do I have? Yes, okay, 10 minutes. Okay, so you can comment during the official DEIR comment period. Or you can comment anytime, actually, up till the project is approved, at the end of the final hearing on the project. And this last alternative, the second until project approval, the defense lawyers really hate. It's just like you throw in stuff over the transom right in the city council meeting. Here's a truckload of documents, throw these in the record. They have no idea what it is. They can't look at it. But the thing is, it might annoy them more, but it's less good for you. The advantage of commenting during the official comment period is that they have to respond. And if they respond inadequately, then you can use that as a claim in your lawsuit.
Can you incorporate stuff by reference?
Oh, yeah, well, incorporate stuff by reference. Actually, I think I might have. Yeah, actually, I'm skipping ahead 2 slides here. The short answer is yes, but you don't really incorporate it by reference. What you can do is you want to submit things that are evidence, like studies done by people. You want to prove that global warming really exists. So, the judge may be skeptical about that. There may be nothing in the record about that. So you submit like 5 studies from people, from Science Magazine saying global warming really exists. But you don't just throw those in the record. What you do is you have a comment letter that says how they apply to this particular case. So you'll say, your global warming analysis is inadequate because blah, blah, blah. But yes, it's important. People often put in 1,000 pages of documents, attached to a comment letter, but the comment letter goes through and says how all of those pertain. There's pretty good case law that if you just do a data dump, you throw in 2,000 pages of studies and don't say what it is, they can ignore that, and it's not going to do you that much good. So also, expert opinions are better. And we're trying at the Sierra Club to come up with a list of people who are kind of sympathetic to our cause and willing to comment, geologists and biologists and stuff like that. So any of you know anybody like that who we should talk to, we'll probably put this list together this summer, email me, and I'll be glad to do the footwork, or I'll have an intern do the footwork or something like that. It's an asymmetrical game, this EIR thing. They have years to put this thing together. They're typically thousands of pages. They have to do 100 pages on water supply, and 100 pages on water quality effects, and 100 pages on traffic. So they have all these studies. They pay big money for their experts. They have these expensive consultants. They have lawyers review it. It takes forever for them to try to bulletproof it, because what they want is an adequate analysis that's defensible in court. You come in with your small little window of time and money. All you have to do is find one significant enough flaw in that EIR, and you're going to win in court. So, they have all the resources and all the time, but you have this thing like you just need one thing. There is this concept that I've labeled. Actually, it was opposing counsel in one of my cases during the argument came up with this concept of mortal versus venial sins, and the day before Easter is probably a good day to spell that out for you in case you're not Christian enough to know what that means. I mean, a mortal sin is one where you go to hell if you do it. A venial sin, I think you only go to purgatory and you can get out after a while. In the context of CEQA, mortal is like it's a big enough thing that it's fatal, and you'll get the EIR thrown out. There are lots of small things. You failed to notify a respondent agency over something that they might possibly be responsible for. There are a lot of little technical things where you're not going to get the EIR thrown out. So it's not just any little thing. It has to be pretty substantial.
Fatal flaw.
And so these are some things to look for, sort of add them to Jeff's list. Baseline is the status of things on the ground now. that's what you're supposed to be comparing the effects of the project to. So that should be in the project description. And as I say, the future effects are compared to that. So one area where they often don't do that is traffic. You know, they'll say, if you have a project that's being built in phases, you know, phase 5 might be 15 years from now. And they don't want to compare 15 years from now traffic to the way things are now, which is pokey and nobody ever drives anywhere around there, so there's no traffic problem. What they want to say is in 15 years, everything's going to be so built up there that our little extra project is not going to make any effect. So they're trying to compare what's projected for 15 years from now without the project to what's projected for 15 years with the project. And you say, no, you don't get to do that. You've got to compare it with now, and of course there's going to be a bigger difference between now and 15 years with the project than there is from 15 years without the project and 15 years with the project. So that's an improper baseline, and EIRs have been shot down on that traffic issue. But that is generally something to be watched out for. Always find fault with the global warming analysis. You know, sometimes you win on that, and sometimes you don't. But there's no really good established methodology for that right now. So it's always worth a shot. I already talked about blatant failures to follow the law. Public trust violations, I put this down there because I just got a really great article from a lawyer that we're working with at Advocates for the Environment on sort of the public trust, and it's on the website. So take a look at that write-up. Public trust is basically there are certain resources that are held by the state in trust for the people, like beds of rivers and parts of the coast. And those cannot be given away by public entities for non-trust purposes. So I think I will, I thought there was one more point. No, I think I will finish on time since I have 30 seconds. She came back just in time. She was like, why did you walk? Get back to the 30 seconds before he's done. Make them count, yes, instead of blathering on my personal, yes. Okay, CEQA is under attack in the state legislature. So we've talked about that a little before. You can find out about what's going on the CEQAworks.org site or the PCL, the Hunting and Conservation League. They're really working to help defend it. And I want to encourage you all to donate a little bit there to help save CEQA. It's a really important resource for protecting the environment in California. And you know, instead of you're getting a free lunch today and a free day worth of education, and you know, if you feel like you should pay something for that, then donate that to CEQA, please. So no time for questions.
Hey, Dave, if I can make one last pitch for CEQA. CEQA is looking for organizations. If you are a member of an environmental organization or anything, they are looking for people to sign on to support CEQA. So go to CEQAworks.org and sign your organization up to that.
Who's running that website?